Abusia yabeda masene amama kwa abadom aba Ayeka TV so musumfu KVS nie abusia wonya subscribe ya anidie kwan so na wabomode anu subscribe na afi nso achewa adwen e comment section honum na bibia aya kama abusia Excellency John Dramani Mahama ne second come yi na sese de o kire se Ghana ye judiciary system no efi e wo honum enti oba be ye clean up exercise wo honum wo judiciary system ho bia osusu se uwo particular ewo nipadua mu bia no His Excellency John Dramani Mahama kire se oba be yi sa ankofo ni nyina afiri honum no de amanfo foforo aba betina honum no mo ahwe ama ensema hodo a yedi ewo Ghana ha ye court issues ahodo ni nyina no akoboko wa abra obi mfa ne party nioma ewe ne mu enkosisi obia na no ena obae no kire se maami Chief Justice Maami Tukuno aye nneoma mienu baako mienu miensa bia according to His Excellency John Dramani Mahama ene amanfo bia chiro petition de bre John Dramani Mahama no omo kire se saa nneoma na Maami Tukuno eyeye no amfa mra kwan so amfa mra antu ba bia ewose wode to nti ewose yi ni free honom na ede obi fufuro ba ama ehwo asem aba be yedeja wo manimu a akokot bebre ena o ma hye se omunyi asem no na omo nkoka no okukuam nti omugusu a omo ka asem no okukuam as to say yebeyi Maami Chief Justice right now kra no o ma suspend no but as to say yebema no indefinite suspension ne ade obi fufuro aba be hye honom ana say eye suspension na yede ba no yebetwa so na maame no aba betua na adwuma so eno na eye committee a yetisi honom no omunyina ehwe se obi abetie afanu nasem na ba bia no kreda no omode ato na no na lawyers ni bi ede ensem bi aba betoto ho a omo chese ensem a lawyers no ede aba betoto ho ne de sisi de jubilation ewo maame eyetuko no kampa enya asem ketua nti nsem ni nyina aba be kan Ayeka TV app no so a yenso ye ba be bo awram na yatietie nsem ni nyina na abusua ye nyina no yenya eho ntiase nti ye be bo awram ya kwakotie nsem ni nyina se de na omo ka no
AG to represent the CJ in court? That's the first question. And I answer straight away. There is nothing wrong with the former AG Godfred representing the CJ. Why? Godfred now is a private legal practitioner. As a private legal practitioner, if you are consulted by a client, you may choose to take the brief or reject the brief. And so if he has chosen to accept this brief and represent the CJ, there's nothing wrong with this representation. Again, it is the right of the CJ, as something you said, to pick any lawyer of her choice. The CJ has examined most of the lawyers in this country, and he decided that Godfred should be the person that she thinks should represent her interests in this particular matter. What's wrong with it? There is this argument that this current suit by the CJ is an attempt to frustrate the hearing. That argument is also flawed. The CJ, as a citizen, has the right under the Constitution to vindicate anything that's bothering her by going to court. And one of such is when she's being removed from office. And I dare say, the CJ reserves the right to challenge every step along the way because it is allowed under our Constitution. And one of such steps is what she has done by commencing this action in the Supreme Court. In the current action at the Supreme Court, she's asking for various reliefs. I'm not going to judgment her because I know where I need to tread. But I'm going to state my own opinion, but I will not judge. If the CJ tells you that two of the panel members, I will say panel because they are part of the committee, who are judges, may have to look at their position relative to being part of that committee once again. I think it's a fair demand. Now, even if you go to the chief's palace and there's a matter before the chief has empaneled some chiefs to sit on your matter, this would give you a right to raise an objection as to the inclusion of any of the members of the panel. And so if the CJ is now saying that looking at the issues at play, Justice Poaman sat on some cases, and those cases have formed part of the basis for her removal from office. And for that matter, she has the opinion that it's because to make a determination that Justice Poaman is not qualified to sit in the matter. I mean, that one is a fair request. As whether to the Supreme Court, we leave it. The second one also has to do with another case where the CJ sat with other judges, including Justice Poaman. And that particular case is being used for her removal. The CJ says, wait, if you are going to remove me based on this case, a panel member of this committee sat on that panel. So let me ask this question. Whatever the CJ says that she may want to call Justice Poaman as her witness related to that allegation in that matter, what happens? She tells you, yes, Justice Poaman is my witness in that case. And so you look at the optics and look at the real circumstances. The CJ had no option but to go to court.
The question arising from what you just brought up has been that, first of all, who empaneled these judges to sit on the matters that she's complaining about?
The president, on advice of the Council of State.
No, the matters that she's complaining that they sat on that matter involving one of the petitioners or more than one of the petitioners, and therefore they shouldn't sit in judgment of her. Who empaneled?
All right. She empaneled as the Chief Justice.
Right. When she empaneled them, was it her expectation that what they would do would be personal?
Not personal.
But applying the law, right? But applying the law and doing justice, right?
Exactly.
So why does she have a problem now?
You see, she has a problem per her rates because that decision that they took wasn't her personal decision. It was a decision of the panel. And if you are not going to question her based on that particular decision, it will be fair that all members of that panel may have to stay away from it, from interrogating what she did on that particular matter.
Maybe they being part of the panel rather will benefit you.
That's why I posed the question. So if she decides that Justice Poaman is my witness, I want to call him as my witness related to that particular allegation, what happens?
Well, how do you answer to the question that in the Daniel Esiedu matter, for example, she had the opportunity to deal with the matter previously. And then when it came before her, when she was Chief Justice, she didn't see that, what she's raising now was substantive. And so she went ahead. How about that?
I mean, Samson, we do not know the full facts in that particular matter, but I understand that in one of such cases, she was not even part of the panel because she has sat on that case at the Court of Appeal. And I stand to be corrected. And so in those 4 cases, if you have one judge who sat on them, and there's an allegation against a certain Chief Justice related to those particular cases, wouldn't it be fair that that judge does not form part of the panel that's seeking to interrogate that particular matter? Fairness, as we all know, is something that we must all see that is being done or is being done.
Okay.
And let me move further to address this issue about in-camera hearing. or on camera. I mean, that's the problem. Is it in or on?
In or on camera. Is it her right to waive?
Let me address you, Samson. Now, if you take Article 146.8, as you read, a careful reading of it, you say, oh, this one is so clear. But we are taught that if you want to know the true interpretation of a clause in the Constitution, you must read the Constitution as a whole. And so if you take Article 19, Clause 14, it's to the effect that if you are hearing every matter, it should be by public hearing, unless that commission or that committee comes to effect to say that, no, this matter must be heard in private or in camera. And if you also go further, look at Article 281.
No, the article you just referred, does it not defeat the argument that it should be public? Because this provision says it should not be public.
Yes, I'm building an argument.
Okay.
If you look at Article 19.4, it says it should be in public unless or until the committee or the commission says no, it should be in camera. Article 281 has the same provision. And why are they saying that those two provisions they can be held in camera? On three main grounds: that if that body is of opinion that based on public morality, public safety, and public order, they may want to say, let's hear this matter in personal circumstances. What is the spirit or the rationale behind Article 148 and 146.8 of the Constitution? The rationale could be deduced not from the plain text, but you may have to look at the spirit, having in mind other provisions. And in the other provisions, the catchphrase is public morality, public safety, and public order. And so in interpreting Article 146.8, you will have to look at the situation to see whether indeed, in the circumstance of this case, public morality will be defeated, public safety will be defeated, or public order will be defeated. And we should also not forget that they say all proceedings should be in camera. But the proceedings have already leaked. The proceedings have already leaked before we read the proceedings.
When proceedings get leaked, there are sanctions, right?
Samson, I'm coming there. When proceedings get leaked, we are told in the dairy case that it will not vitiate the proceedings, so-called. When they get leaked, even the provision that talks about shall, the Supreme Court said no, notwithstanding that one, it will not vitiate the proceedings. And so the taking of the Supreme Court in dairy cases to the fact that the leakage of the proceedings or not is inconsequential. And so the use of the word shall there in the Constitution, to my mind, could be interpreted to mean may. And we should not forget, once again, that the Supreme Court in other cases have interpreted shall to mean may.
Like?
You look at the Article 49 of the Constitution.
No, you said signing in other cases, correct? Signing of pin sheets.
Yes,
right.
that's what I'm giving you that one.
Okay.
Article 49, dealing with shall, the presiding officer shall sign, etc., etc. Let's go back to 2013 election petition. What was the holding of the Supreme Court? And so you may have shall there, but looking at the purpose or the intendment of that provision, is it possible for the Supreme Court to rule otherwise?
You think?
And so this particular matter,
you think the two situations are the same?
Samson, the Supreme Court.
The Supreme Court said the presiding officer is supposed to sign, but his failure, sign. Yes, he must sign, but his failure to sign should not be held to invalidate the vote, because the vote was held in the public, it was counted in the public, other parties to the election process also signed. So you cannot punish the voter and all other stakeholders for the sins of the presiding officer. Is that reasonable to you?
Excellent, Samson. So you see here, the Supreme Court decided to look at other circumstances to say, not to stand the shall, it should not affect the outcome.
Correct.
The Supreme Court decided to look at other circumstances, other factors. That is the same way that this case is seeking to do. You look at the circumstances, the factors, the Supreme Court may, I'm not saying they are going to do that. I'm just expressing an opinion.
So here, what makes the circumstance, whatever, that should call on the court to deviate from the clear provision? What do you say? That public morality, public safety,
and public order.
How?
Samson. Already, as I said, the petitions are out there.
That is a breach.
So that is a